Vegas and Rich should go into a breakout room and discuss their case unless you already have a resolution of the matter. What we will do this morning is go through the cases. If it is a non-payment of rent case, I will ask the attorneys that rent due on the record. If you, tenant, agree that that is the correct amount, judgment will enter in the matter. If you dispute it, we will get you moved into a breakout room so that you have the opportunity to speak to the attorney. Attorneys, if you have multiple cases, you should have a representative from your complex available to meet with tenants while you are in this main session, having conversations about balances with me. That being the case, everyone either already have been checked in by Carly or currently being checked in. We will get this docket going. People who have caps on, this is a courtroom. Although you're not physically in the courthouse, this is still a court session. Please remove your caps and hats. The last factor is, well, there's two more things. I do not have my regular secretary. I have borrowed staff from other parts of the building, so be patient with them. Last thing, we are using a new file management system, which takes a little bit to navigate, so please be patient with both myself and staff as we work through the docket. All that being said, and Sandy, I see, let's refresh because I don't see, oh, here we are. Here's the bench. Wonderful. First case up is 2300154LT. This is Belleville Meadows versus Michelle Young. May I have your appearances, please?
Morning, Your Honor. Robert Visconti, P61756 for the plaintiff.
Ms. Young, you need to unmute yourself. Wonderful.
Yes.
State your name.
Michelle Young.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Visconti, what is the rent to retain possession in this case?
Rent through September, Your Honor, is $4,910.74. I show court costs of $170.68 for a total of $5,081.42.
Ms. Young, were you able to hear Mr. Visconti just now?
Yes.
Is the amount of rent claimed due and owing in this matter accurate?
Yes.
Ma'am, inasmuch as you admit and agree that the amount of rent claimed due and claimed due is accurate, there is not a tribal issue of fact, and plaintiff is entitled to entry of judgment in that amount. Mr. Visconti's office will prepare and submit to the court a judgment that reflects the rent to retain possession is $4,910.74, $170.68 in court costs for a total of $5,081.42.
Can I say something, Judge?
Absolutely, ma'am.
Okay. I am moving. I told them I was going to pay them in a payment arrangement. My thing is I just needed more time to move. I needed a few more weeks to move. So that's what I wanted to make it.
How much time do you need, ma'am?
Of 2 weeks. By the end of this
2 weeks
month.
from today?
Yes, ma'am.
Mr. Visconti?
Your Honor, I believe the applicable writ date would already extend us to what, the 2nd?
Ms. Young, will that be sufficient time, October 2nd?
Yes.
So, yeah, we'll prepare an order to that effect, Your Honor, and submit it for entry.
Anything else, Ms. Young?
My concern was it wasn't just not paying the rent. They told me they was not going to re-sign my, I just want to make this known. They said they was not going to re-sign my lease for me to move out at the beginning of September. I had plans on that, but I was entered to a new job, which made my money. That wasn't even a case to try to find a place since they wasn't going to let me re-sign a lease. So I had to move anyway. So that's why so much. And I was moving, but I wasn't moving by September. My plan was to move by the end of this month because the maintenance people, and I complained to them, they've been coming into my home unannounced. I'm a graduate nurse, so I'm barely there. But when I get there, I see stuff out of order, and I call the office and they say, oh, they came to fix this and that, or they wasn't here this day. But I also have witnesses that state that they've been seeing people coming in and out my apartment, and there's no reason why they should if I'm still living there. And so that was my complaint. So I feel very unsafe. I am moving. They keep calling, like harassing me about their payment. I told them they will know the information once I have court today. But I feel very unsafe there. I am moving. I do not want to stay there because the maintenance man been coming in and out my apartment, and I made it known to them. Yes, I owe them. It was their choice not to re-sign my lease, let me to re-sign my lease. So I told them it takes time for me to save up to move. I just cannot move up like that. I just started a new job. Like I said, I'm a graduate nurse. I'm trying to get my life together and I'm trying to move off their place, but I don't want to be harassed and people walking in my home unannounced. So I've been staying at my daughter's house because I'm afraid of people walking in when I'm sleeping. So yes, I will be gone in 2 weeks, by the 2nd of October.
Thank you, Ms. Young. Then what will happen is Mr. Visconti's office will send a judgment that reflects those terms to the court. I'll sign it. A copy will be mailed to your attention at the address we have on file. I'm sure Mr. Visconti will relate to his client that there is no need to follow up with you further. Anything else, Mr. Visconti?
Nothing further for the record, Your Honor. Thank you.
Thank you. Ms. Young, you are free to go. You have a wonderful day. Thank you, ma'am.
Thank you. You too. Bye-bye.
Are we ready on 2300609 LT Colburn versus Clark?
Yes, Your Honor.
Yes, Your
appearances,
Honor.
please.
Jason Sakis appearing on behalf of the plaintiff, Your Honor. Mackenzie Colburn, who was also in the Zoom room today.
Brian Rich on behalf of defendant Lauren Clark, who is also in the room.
Thank you. How are we proceeding this morning?
Judge, if I could just give some background, this case was originally a case for possession. Since the filing, from the answer that was filed with the court, our understanding is that the defendant, Lauren Clark, has moved out. We're asking for a judgment of possession, but there is a counterclaim that was filed, and there was an amended complaint that was filed. So my suggestion is, although I defer to the court, we're asking for a judgment of possession today to confirm the fact that Mackenzie Colburn should have the property, and to let the counterclaim and the claim for damages to the property be addressed on a different date, since the pleadings haven't been fully addressed yet with the court, Your Honor. I'll be quiet now. I'm sorry.
Mr. Rich.
Yes, Your Honor. So the defendant moved out of the premises more than 3 weeks ago. We notified opposing counsel. She left the keys to the property. There is no reason for a judgment to be entered where the defendant would in the future need to answer the question, have you ever had a judgment entered against you, where she would have to answer yes. There was an issue as well with respect to whether the complaint was filed in the appropriate time frame, because there was an allegation of physical threats of violence, but the documents that were provided by plaintiff, the police report, makes no mention of physical violence. It simply identifies that they had a verbal altercation. So we have issues with the timing of the filing of the complaint. It should have needed to be refiled, and because defendant has already been gone for more than 3 weeks, there's just no reason to enter a judgment against her. With respect to the counterclaim and an amended complaint, I do agree that those could be addressed on another date. I don't know if the court would want to issue a new case number with it no longer being a landlord-tenant matter, but I leave that to the discretion of the court.
Well, Mr. Rich, I'll get back to you in just 1 second, but Mr. Rich, the issue is that the answer indicates that the defendant vacated the property, but it didn't give a date. So
I
don't know how you get around the fact of having the plaintiff have to get a judgment for possession.
Well, there's two issues. So first, as Mr. Sakis knows, she vacated the property on August 29th. And that was before the first hearing in this case. The keys were left at the property, and I believe that the case was filed prematurely. So typically with a notice, with a notice to quit, it says you need to vacate or a complaint will be filed. Well, she has vacated. The original complaint was filed
Well,
prematurely.
Mr. Rich, nope, I'm sorry, I'm interrupting you because there are other people from the 9 o'clock docket who we still need to talk to. The court is prepared to take up a full hearing on this matter, possession and damages, next Wednesday afternoon at 1 p.m. If that will give you sufficient time to be prepared to have a hearing where witnesses will be sworn, testimony taken. You want to check your calendars?
From the plaintiff side, we're prepared to proceed.
So, Your Honor, will that be with respect to all claims, the counterclaims?
Absolutely.
Okay. Let me just double check. Wednesday, the 23rd. No,
The 27th.
yes, at 1 o'clock.
9/27 at 1 p.m. by Zoom. If there are documents that you want the court to consider, there's not a screen sharing function. Did you want Zoom or in person, Mr. Sekis?
Your Honor, I would prefer in person, but whatever your preference is, I only say that because I have some documents regarding damages. I also wanted to tell the court, I'm not sure if an answer to the amended complaint was filed yet, but I'll get my answer into the counterclaim. But I know you weren't asking that. I'm just saying whatever your
No,
preference
I
is,
am
Your Honor,
asking,
I'll
no,
do.
no, no, I am asking that. I have no preference. I'm here.
I would rather do it in person because it's easier for me with the documents, but if you, whichever Mr. Rich wants and you want, Your Honor.
Mr. Rich, are you available for a live hearing next Wednesday at 1 p.m.?
That would be difficult. I think it's probably just as easy to submit the documents to the court. I don't know if the court accepts those electronically or if they would want them as mailed to the court. But I think it might be easier to for everyone in terms of time. I don't know about Mr. Sakis's client. I don't know what my client's employment might require as far as where she may be at any given time.
Let's do this. Mr. Rich and Mr. Sakis, would you take yourselves into the breakout room that's labeled with your names on it? You talk to each other about how you'll exchange documents with each other. When you come back out, I'll recall the case and we'll figure out if next Wednesday doesn't give you sufficient time to do what you need to do, we can do it the following Wednesday, the 4th. But go in there, talk to each other. You're both co-hosts, so you are able to move yourselves into the room that's labeled with your names on it. I'll recall the case when you come out, okay?
Thank you, Your
Thank you,
Honor.
Judge. Thank you, Judge.
Thank you. This is 2300155 LT. This is Belleville and Meadows versus Powers and Powers.
Morning, Your Honor. Robert Visconti, P61756 for the plaintiff.
Antoine Powers.
Where's Colin Powers?
He's not here, Your Honor.
Where is he?
He's in Alaska right now, Your Honor.
He's where?
In Alaska, that's where he lives.
In Alaska. Okay. Today is the day and time set for the second hearing of this matter. The defendants failed to appear for the first hearing. Mr. Visconti, what is the rent to retain possession?
Rent through September, Your Honor, is $913.67. Our court costs are $209.10 for a total of $1,122.77.
Mr. Powers, were you able to hear Mr. Visconti just now?
Yes, Your Honor.
Is that an accurate amount of rent claim due and owing?
Yes, Your Honor.
Sir, inasmuch as you admit and acknowledge that the amount of rent claim due and owing is accurate, there is not a triable issue of fact. The plaintiff is entitled to entry of judgment after hearing as to you and default judgment as to defendant number 2. Mr. Visconti's office will prepare a judgment that indicates as much. File that with the court, and once it is signed, a copy will be mailed to you at the address that the court has on record. Anything else in this matter, Mr. Visconti?
Nothing for the record. Thank you, Your Honor.
Anything else, Mr. Powers?
No, Your Honor.
Thank you. That concludes this matter, sir. You're free to go. You have a wonderful day.
You do the same.
Thank you. Okay, Sandy, I'm having a small technical issue.
What's up, Judge?
I am frozen. Here we go. Sandy, I'm telling you, I'm trying.
Did you save your last notes? Go back to your
did.
user interaction.
No. Oh, okay.
Let me know if you want me to come up there, Judge.
No, don't come up here. I'm good. Thank you.
You're welcome.
Sandy, I'm telling you, it looks so easy in the videos. It is so much more difficult to manage it this way. Oh, see? Thank you, Sandy.
You're welcome.
This is 2300156LT. This is Belvilla versus Lakeisha Reed. May I have your appearances, please?
Robert Visconti, P61756 for the plaintiff, Your Honor.
Lakeisha Reed. Today is the day and time set for the second hearing in this matter. The case was scheduled at 9 o'clock. It's now 9:20 by this court's clock. Defendant having failed to appear. Mr. Visconti, how would you like to proceed?
I'd move the court for entry of a default judgment for possession, Your Honor. For the record, rent retains $1,419. Costs are $170.68 for a total of $1,589.68. I would submit an order with a writ to issue after October 2nd if that amount's not paid in full.
Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $1,419. Cost of $170.68, Mr. Visconti.
Yes, Your Honor.
Thank
What
you.
name did you say again?
I'm sorry, who was that?
What name did you say?
I said Lakeisha Reed.
Oh, no, I'm sorry.
You're fine. Plaintiff's office will submit that judgment for entry on Belvilla versus Reed. This is 2300211LT. This is Metro Commons versus Selena Brown.
Robert Visconti for the plaintiff, Your Honor.
Selena Brown. Today is the day and time set for the second hearing in this matter. The defendant failed to appear for the first hearing, has failed to appear for the second hearing. Mr. Visconti, how would you like to proceed, sir?
Move the court for entry of a default judgment for possession, Your Honor. Rent to retain in this case is $3,452.64. Costs are $170.68 for a total of $3,623.52. Possession only with the writ to issue after October.
I'm sorry, Mr. Visconti, I'm getting feedback from somewhere. 3,620.
$3,623.32.
Defendant having failed to appear for a second time as ordered by the court, default judgment shall enter in favor of plaintiff and against defendant with a total judgment of $3,623.32. Plaintiff's office to submit that judgment for entry. Anything else in this matter, Mr. Visconti?
Nothing further, Your Honor. Thank you.
Thank you. This is 2300215 LT. This is Metro Commons versus Taurus Holland. State your name for me, please, sir.
Taurus Holland.
Thank you, Mr. Holland. Today is the day and time set for the second hearing in this matter. Mr. Visconti, the rent to retain possession.
$3,641.09, Your Honor. And we show court costs of $170.68 for a total of $3,811.77.
Mr. Holland, were you able to hear Mr. Visconti just now?
Yes, ma'am.
Was that an accurate amount of rent claim due and owing by Mr. Visconti?
Oh, yes, that's accurate.
Mr. Holland, in as much as you admit and acknowledge that the amount of rent claim due and owing is accurate, there is not a tribal issue of fact, and plaintiff is entitled to judgment in that amount. That amount being $3,641.09. There is $170.68 in court costs for a total judgment of $3,811.77. Plaintiff's office will submit that judgment to the court for entry. A copy will be mailed to you at the address we have on file. Mr. Holland, did you have any questions this morning?
Yes, ma'am. The money order was going to be taken over this morning. I'm not for sure how that's worked. Like, am we still moving forward with the process? On the 22nd, like, I was going to put the last money order in there, but they always add the following, the current, the next month on there. So that was causing me trouble.
Yeah, the next month's not due yet, Your Honor. So the amount that's on the judgment would be cured with payment by October 2nd. October rent's not at issue at this point.
Okay, well then that's fine. Friday, the full amount will be in there.
Mr. Holland, what will happen is Mr. Visconti's office will send a judgment to the court that shows that total amount and will indicate that you have until October 2nd to pay or vacate. It only includes rent due through September. So as long as you pay the amount at $3,811.77 on or before October 2nd, that will conclude this matter. And then
Yes,
October
ma'am.
will come due on October.
Okay.
Anything else, Mr. Holland?
No, that's all, man. Thank you.
Thank you, sir, for your patience this morning. You have a wonderful day, okay?
Thank you, Your Honor.
This is 2300219 LT. This is Metro Commons versus Alonzo Smith and Shannon Turner.
Robert Visconti for plaintiff, Your Honor.
Thank you. Alonzo Smith or Shannon Turner. This case was scheduled for hearing at 9 o'clock. It is now 9:25 by this court's clock. Defendants have failed to appear in this matter.
Your Honor, I'd move the court for entry of a default judgment for possession.
Mr. Visconti, I'm sorry. I'm trying to move through on base.
Okay.
Default judgment to enter. Defendants failed to appear. Now your amounts, please, sir.
Rent to retain, Your Honor, is $2,280.15, 1-5. Costs are $209.10 for a total of $2,489.25.
Thank you. Defendants having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with a total due of $2,489.25. Plaintiff's office will submit that judgment for entry. Anything else in this case, Mr. Visconti?
No, Your Honor.
Thank you. Yes, Carly.
I'm sorry, I just jumped over and it's not.
No, you're fine. Someone just arrived that was supposed to be here at 9 o'clock. Ms. Lakeisha Reed will circle back to Mr. Visconti's case with her. But I've already sent the file electronically downstairs to Sandy. This is 2300255 LT. This is Country Metals versus Lakeisha Washington.
Good morning.
Morning, Your Honor. Attorney Ian Morton, Appellate's Law on behalf of Country Meadows.
State your name, please, ma'am.
Lakeisha Washington.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Morton, what is the rent to retain possession, please?
Here at this time, rents retained is $6,607.00. Core costs of $167.65 for a total of $6,774.65. This is a possession only action.
Ms. Washington, were you able to hear Mr. Morton just now?
Yeah,
Is that amount of rent accurate?
yeah.
Ma'am, do you have any defense to this non-payment of rent action?
Well, I had surgery.
And ma'am, how do you intend to proceed in this matter?
Well, it'll be paid. I just need to the October 6th.
Mr. Morton, are you authorized by your client to extend the writ date in this case?
I could potentially do that, Your Honor, but we would ask that the October's rent be added on there as well, since it is going well into
Okay.
October past the grace period.
That's fine.
So, Your Honor, then I would propose that I can submit a consent judgment with the current balance due of $6,774.65, which includes the court costs. Additionally with October's rent, and charges being added on, which will be due and owing on or before October 6th, 2023.
Mr. Morton, do you want to speak to Ms. Washington in a breakout room regarding that as a consent judgment?
Absolutely. I'll go through that with her, Your Honor, so we can put on the record, efficiently.
Thank you.
Yep.
Ms. Washington, you'll see an invitation to go into the breakout room with Mr. Morton. Please go there. He'll talk to you about the consent judgment. If that's something you want to do when you come back out, I will recall the matter and we'll put the terms on the record, okay?
Okay, thank you.
Thank you. This is a recall of 2300609 LT. I have your appearances already. This is Coburn versus Clark. Have you gentlemen come up with some way to proceed in this matter?
Yes, Judge. I didn't mean to speak, but we have an agreement. We were going to do it in person because we have witnesses regarding the damages to the property, and Mr. Rich would want to examine them. And I think if we did it over Zoom, it might be too difficult. Having said that, I need to contact these people that I've never talked to who are contractors, and Mr. Rich has a conflict on October 4th. Could we get a date sometime after October 4th with you, Your Honor, and then we will exchange exhibits to consent to as many and stipulate to as many as we can to make it easier for you, and then we can have everything streamlined. But just some date after October 4th, if possible, Your Honor.
Sandy?
Yes, Judge.
I'm sorry, I don't have JIS in the courtroom. Could you look and see what October 17th looks like maybe? Mr.
Yep.
Rich and Mr. Sekis, if you could check your calendars on October 17th, please.
Sure, I'm going to do that now. Thanks, Judge. That's
It looks like you have some probable cause and prelims, 8:45, one probable cause, and 11, you have a few.
On October 17th?
Oh, nope, that's 18th, sorry, October 17th is
Oh,
clear.
don't scare me. It was like criminal
I'm
day on
sorry.
Tuesday. No, that's not.
Your Honor, it
17th
looks
is
like
clear.
it looks like my client has a conflict on the 17th. I know she was going to be available on the 11th, but I don't know if that gives Mr. Sakis enough time.
I don't know what the judge's schedule is, Judge. I'll make myself available whenever you're able to do it. I'm okay on the 11th. I'm okay on the 17th that you selected, Judge.
No, the 11th, somebody just has to check the calendar.
I just did, Judge, and you're
There's
clear.
nothing.
There's nothing on
Thank
the
you.
11th.
October 11th? In person, at what time, Mr. Sekis? Do you have a preference?
I have depositions in the morning, but in the afternoon, I'm free and can be there and ready to try the case.
Mr. Rich, is 1 p.m. okay with you on the 11th?
1 p.m. would work, Your Honor.
Ms. Coburn and Ms. Clark can check their schedules as well, and if they're able to, if that's a date that they're able to,
October 11th is fine for me.
That was Ms. Colburn. She's okay with that, Judge.
No,
Ms.
Your Honor,
Clark,
I think
same
that works
question.
too. All set there.
Okay,
Thank you.
thank you. Court staff will mail out notice for an in-person hearing on October 11th at 1 p.m. in courtroom number 1 at 34th District Court. If there's anything that you want me to consider beforehand, you're able to file that by my file on base. Otherwise, I will see you here on that date at that time. Anything else on behalf of the plaintiff?
Nothing, Your Honor. Thank you very much.
Anything else on behalf of the defendant?
No, Your Honor, thank you.
Thank you. Thank you all for your patience this morning. You're free to go. Ms. Clark and Ms. Colburn, you have a wonderful afternoon.
You too, Your Honor. Thank you.
You too, Judge.
you.
Thank you.
Bye-bye, everybody.
You as well. Thank you.
Okay, this is 2300275 LT. This is Belleville versus Markeisha Beverly and Drake McKee.
Robert Visconti for plaintiff, Your Honor.
Markeisha Beverly.
Ms. Beverly, do you know where Drake McKee is?
He's currently at work right now.
Today is, thank you, ma'am. Today is the day and time set for the second hearing in this matter. Mr. Visconti, what is the rent to retain possession in this matter?
$1,220 through the month of September, Your Honor. Our costs are $209.10 for a total of $1,429.10.
Thank you. Ms. Beverly, were you able to hear Mr. Visconti just now?
Yes, but I don't agree with the amount.
Okay.
I paid my rent last week. I should have a zero balance.
You, ma'am, when did you pay?
I paid on the 14th of last week.
Did you get a, ma'am, turn your video on. Did you get a receipt from the apartment complex?
I paid online, so it's on my portal.
Okay, then ma'am, what we'll do is we'll pass this matter briefly. Mr. Visconti. Mr. Visconti, it looks like this is your last case of the morning. If you could check with your client. Ms.
I'd be
Beverly,
happy-
I will circle back to this matter in just a moment.
Thank you, Your Honor. I'll give them a call.
Thank you. This is 2300616 LT. This is Colleen Anaceto versus Christy Stanchfield and Shannon Johnson.
Good morning, Corinne Ford for the plaintiff.
Christy Stanchfield or Shannon Johnson. Today is the day and time set for the second hearing of this matter. Case was scheduled at 9 o'clock, is now 9:36 by the court's clock. Defendants having failed to appear. Ms. Ford, how would you like to proceed?
I'd like to
I
proceed.
believe there's a Devante here for this case. I don't know why he's not answering.
I'm sorry, Sandy, it's Devante
Oh,
Ware.
no, sorry, wrong case.
Thank you. Ms. Ford.
I'd like to proceed with a default judgment against both defendants, please, with a move-out date of 10/2/23.
Defendants having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with a writ date of October 2nd. Ms. Ford, if you would have your office submit that to the court for entry.
Will do.
Anything else
Thank
this
you.
morning?
Nope, that's it. Thank you, Your Honor. Have a good day.
Thank you. You too.
Bye-bye.
Bye-bye. I saw your message, Sandy. Just give me a moment. Thank you. This is a recall of 2300255 LT Country Meadows versus Lakeisha Washington.
Thank you, Your Honor. The parties have spoken, and then we do have a proposed consent judgment to place in the record.
Yes, sir.
Terms are as follows. Was it rents retained of $6,607.00, core costs of $167.65 for a total of $6,774.65. The parties have agreed to an extended payment / writ date of October 6, 2023. In the further ordered section, it will also state October's rent and utilities is also due on October 6th. I did advise Ms. Washington of her rights, specifically as it pertains to the 3-day time period, as well as her right to appeal. And she did give me permission to place her name on the proposed consent judgment, Your Honor.
Thank you. Ms. Washington, were you able to hear Mr. Morton just now?
Yes, I did.
And ma'am, is your understanding and agreement that a consent judgment will enter in this matter, indicating that you owe $6,607 in rent, $167.65 in court costs for a total judgment of $6,774.65, and that you will pay this amount along with the October rent and utilities on or before October 6th, or you will vacate the premises?
Correct.
And ma'am, you understand that because you are not represented by an attorney, this judgment is not final and enforceable for 3 days.
Yeah.
And ma'am, because you appear virtually, there is not a signed consent judgment. You've authorized Mr. Moore's office to sign your name to the consent judgment.
Correct.
Do you have any questions at all, ma'am?
Nope.
Thank you. Mr. Moore's office will prepare that consent judgment, file it with the court. The court will sign it and a copy will be mailed to you at the address we have on record. Anything else in this matter, Mr. Morton?
No, Your Honor.
Anything else, Ms. Washington?
No.
Thank you. That concludes this matter, Ms. Washington. You're free to go. Thank you for
Okay.
your patience this morning.
You're welcome. Have a good day.
Thank you, Your Honor. I believe that's the only case we have today, which is a nice short docket for us.
Have a good day, Mr. Morton.
Thank you.
This is a recall of 2300275 LT Belvilla versus McKee and Beverly. Ms. Beverly, the court has received communication that this matter will be dismissed. Do you have any objection to the matter being dismissed?
No.
Mr. Visconti's office will prepare a dismissal of the matter, send it to the court for entry. Anything else, Mr. Visconti?
Nothing further on this matter, Your Honor.
Anything else, Ms. Beverly?
No.
Thank you, ma'am. You're free to go. You have a wonderful day.
You as well. Thank you.
Thank you. Is it Remke? Ms. Remke? Remke?
Yes, ma'am.
Which is it, ma'am?
Miss Remke.
Ms. Remke, I should have recognized those windows. So ma'am, what's the best way to route people to you for rental assistance?
If you could just have them email me, or if I can go into a breakout room as needed, I can give them the link.
So let's do this. We'll set you as a co-host. At the conclusion of a hearing, I'll ask if people want to speak to you, and if they do, we'll let you get them moved into a room.
Okay, thank you.
Okay. Mr. Visconti, do you have something else?
So, Your Honor, I saw that it appears that Lakeisha Reed
Reed, thank
come
you.
in late. We entered a default judgment earlier, but I think the court wanted to recall that.
Thank you. This is a recall of 2300156 LT Belvilla versus Lakeisha Reed. Ms. Reed, state your name for the record, please, ma'am.
Lakeisha Reed.
Ms. Reed, your case was called at 9:20. It was scheduled at 9 o'clock.
I was in a different Zoom. I don't know why the Zoom number. I was in a different room.
Thank you, ma'am. Mr. Visconti, the rent to retain possession in this matter is?
$1,419, Your Honor. And then we have costs of $170.68 for a total of $1,589.68.
Ms. Reed, were you able to hear the attorney just now?
Yes.
Ma'am, is the amount of rent claim due and owing accurate?
Yes.
Ma'am, inasmuch as you admit that the amount of rent claim is accurate, there is not a tribal issue of fact and plaintiff is entitled to entry of judgment and the amount requested. Mr. Visconti's office will submit to the court a judgment that reflects those dollar amounts. Did you have any questions, Ms. Reed?
I was gonna try to pay before the end of the month, hopefully by this Friday. I don't know if that will stop the eviction.
Well, ma'am, it's not quite the eviction stage yet. Today is the day and time for entry of the judgment. The judgment will indicate that you must pay the $1,589.68 by October 2nd or vacate the premises. If you're indicating that you will have that paid before that date,
Yes.
okay. Then the judgment will reflect that dollar amount with the pay or vacate date of October 2nd. Ms. Reed, did you need to be in contact with Wayne Metro regarding rental assistance, or do you have the funds available to pay the judgment amount?
If you can give me the number or email, that'll be.
Ms. Reed, what you'll see is an invitation to go into a breakout room with a representative from Wayne Metro. She will take you into room number 14 and she'll give you that information, okay?
Okay, thank you.
Thank you, ma'am. Have a good day.
You too.
Thank you, Your Honor. Have a nice day.
Thank you, sir. Good to see you.
You as well.
This is 2300129 LT. This is West Village versus Michael Anderson.
Good morning, Your Honor. Gabriel Lacey, P79685 for West Village Estates.
Thank you. Michael Anderson. Today is the day and time set for the second hearing in this matter. Ms. Lacey, I'm just checking the breakouts. There's no one by that name. This case was scheduled at 9:15. It's now 9:45 by the court's clock.
Your
Defendant
Honor.
having failed to appear.
I'm sorry, Your Honor. Good morning. That case should be dismissed.
Yeah, I was just getting to that. I was gonna let the judge finish.
Thank you.
Thank you, Ms. Samples. The court will note that the case will be dismissed. This is 2300167 LT. This is Trilogy versus Shamari Caffey and Tamara Shepherd.
Gabriel Lacey on behalf of Trilogy Residents LLC.
Thank you. I just saw a Tamara check in. Let me see where she went. I just saw that name. Oh. Tamara Shepherd or Shamari Caffey? Tamara Shepherd. The court has now called the case 3 times without response. Case was scheduled at 9:15. It's now 9:47 by the court's clocks. Defendants have failed to appear. Ms. Lacey, how would you like to proceed?
Your Honor, I did just see a Tamara on the screen and now she's disappeared.
I
She
keep
wasn't
seeing her
before.
also, Judge.
It's like she comes in.
I
and then-
saw her, I asked her to turn her video on and I kept calling the case.
Okay.
So I'm with you.
At this point, Your Honor, we would like to ask for a default judgment of for possession only. The rent to retain possession is $6,429.59. Cost of $204.91. Total balance owed $6,634.50.
Thank you. Defendants, having failed to appear in this matter, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $6,429.59. There's $204.91 in court costs for a total judgment of $6,634.50. Plaintiff's office will submit that judgment for entry. This is 2300189 LT. This is Trilogy versus Anaya Hall and Dizella Jones.
Gabriel Lacy on behalf of Trilogy, Your Honor.
Hall or Jones? I see Miss Hall in the waiting room with the clerk. I see her. Miss Lacy, I'll pass this matter for just a moment. This is 2300199 LT. This is Trilogy versus Kelly Roberson.
Yes, Your Honor.
Gabriel Lacy for Trilogy Residents, Your Honor.
State your name, ma'am.
Kelly Roberson.
Thank you. Today is the day and time set for the second hearing. Ms. Lacy, what is the rent to retain possession in this matter?
Rent to retain possession to date is $5,764.95. Cost of $168.28. The total balance owed is $5,933.23.
Ma'am, were you able to hear Ms. Lacy just now?
Yes, I was.
Is that amount of rent an accurate amount?
Yes.
Ma'am, inasmuch as you admit and acknowledge that the amount of rent claimed is accurate, there is not a triable issue of fact, and plaintiff is entitled to entry of judgment in that amount. The judgment that Ms. Lacy's office presents to the court will indicate that a total due is $5,933.23 with a writ date of October 2nd, 2023. Ma'am, did you need to access rental assistance, or did you have a plan to pay the past due rent in this matter?
I'll be paying the rent on the 29th.
Well, ma'am, in the interim, Ms. Lacy's office will submit a judgment by email to the court that indicates the amount of rent and the court costs. I will sign it, and the copy will be mailed to you at the address we have on record. If there's nothing else this morning, ma'am, you're free to go. You have a wonderful afternoon.
You too.
Thank you.
Thank you, Your Honor.
This is 2300276 LT. This is Woodside Square versus Kanaya Austin.
Thank you, Your Honor. Jackie Snyder on behalf of Mark Wallsbury. 82554 is my P number. You represent plaintiff.
Yes, Kanaya Austin.
Thank you. Today is the day and time set for the second hearing in this matter. Ms. Austin failed to appear for the first hearing. Ms. Snyder, what is the rent to retain possession?
I'm sorry, Your Honor, I didn't hear it.
Ms. Austin, what were you saying, ma'am?
I never received the first hearing. This is the first hearing I got about this matter.
Did you receive a copy of the summons and complaint that lists the past due rent?
From my office, yes. Not no court hearing though.
As indicated on the proof of service, Your Honor, the court officer, Mr. Rossi, secured it to her door on the 31st of July.
Ms. Snyder, what is the rent to retain possession?
$801, court cost of $164, a total of $965.
Ms. Austin, are you saying that your notice to appear for this morning was the first thing you received in this case?
Yes, I received the notice to come today. It said it adjourned from the 6th till today. That's the first notice I got. I have no problem with paying it. I already put in my 30-day notice. I can pay it before then. I just don't want no eviction on my name because I just got my Section 8. So I'm already moving. I can pay it. I just don't want no eviction on my name.
Ms. Austin, my concern is that you didn't receive notice. That's a bigger issue and concern for me than anything else. When did you say you'll have the 965 paid?
My worker, I just talked to her, so they're helping me pay it. It will be for October, but I put in my 30-day notice to move anyway already. I just don't want an eviction on my name because that'll mess up my Section 8. So I just want to make sure if I pay it before then, it won't, you get what I'm saying?
Miss Austin, I heard that part of it, and I understand wanting to preserve your Section 8 eligibility. And when I asked you, when you could pay it, it was because I would rather it be paid and this matter be dismissed, so you're not showing a judgment.
It should be, I know, before the end of the month. I'm getting help though from my DHS caseworker, so I can't give you an exact date, but I know it will be before the end of the month.
I understand that, ma'am, but I'm also trying to figure out where we could adjourn the case. You admit that you owe the amount of rent. Ms. Snyder, is it possible to enter into a conditional dismissal in this matter?
It is, Your Honor.
Would you take Ms. Austin into a breakout room and discuss that with her? Ms. Austin, I'm trying to address your concerns as well as give plaintiff the judgment that they're entitled to when you don't contest the amount of rent. So please, you'll see an invitation to go into a breakout room with Ms. Snyder. Go there and talk to her for a moment. When you come back out, we'll resume this matter, okay?
Okay.
Thank you. This is a recall of 2300189 LT Trilogy versus Hall and Jones.
Yes, ma'am.
State your name, turn your video on, please.
Okay, my name is Anaya Hall.
Gabriel Lacey for Trilogy, Your Honor.
Ms. Hall, do you know where Dizella Jones is?
She was just my co-signer. She's not going to participate in the court.
Okay. Understood. Today is the day and time set for the second hearing in this matter. Ms. Lacey, what is the rent to retain possession?
The rent to retain possession is $5,407.94. Court cost of $204.91. Total balance owed $5,612.85.
Ms. Hall, were you able to hear Ms. Lacey just now?
Yes, ma'am.
Is that an accurate amount of rent claim due and owing $5,407.94?
Last time I was given, like just before the meeting was adjourned, I was given a different total. Now it seems like it's $200 more. Is that because it's a different court date? Because it had to be adjourned, so another court fee was added?
No, ma'am. The court costs have been the court costs. There's no additional cost that should have been added between the September 6th hearing and today's hearing.
Oh, okay. Well, either way it go, it has to be paid.
But ma'am, it has to be an accurate amount of rent. And if you dispute the amount of rent that's claimed due and owing, what the court will do is adjourn the matter over. And Ms. Lacey will reappear with her client who's able to give testimony regarding the amount of rent that's claimed due. Unless there's some representative on this morning from Trilogy who is able to go over the ledger with Ms. Hall right now.
I'm sorry.
I do not see a Trilogy representative at the moment.
It's okay. I accept the charges.
Good morning. That Ms. Hall, in as much as you indicate that you don't dispute the amount of rent claim due and owing, Ms. Lacey's office will present to the court a judgment after hearing that shows that $5,612.85 is due and owing. That's $5,407.94 in rent, $204.91 in court costs. The judgment will indicate that you have a pay or move date of October 2nd, 2023. Ms. Lacey's office will submit that judgment by OnBase, which is electronic filing for entry. I'll sign it and a copy will be mailed to you at the address we have on file. Ms. Hall, do you need to speak to someone regarding rental assistance?
I already did. I had last time before the meeting was adjourned, I talked to Wayne Metro. They said I was eligible to receive help. And I actually was. However, my apartment complex refuses to participate. So I have to come up with the remainder of the balance by myself.
I don't know what refuse to participate means.
I spoke to a caseworker from Wayne Metro. She told me that I was eligible to get the payment paid. And she said, but the only thing is she needed to contact Trilogy to make sure that they're willing to participate. When she contacted Trilogy, they said that they don't participate with third-party candidates. They don't participate with Wayne Metro. She said that that's pretty much the only explanation she gave me. She said she doesn't participate, that they don't participate.
That's interesting. If someone owes you money and someone's willing to help pay money. I'm sorry, Miss Lacy, you were saying something?
No, I was saying that's news to me, Your Honor. Actually,
Yeah, I explained to her that the judge and I believe the lawyer that I was speaking with the day of the 6th, they were referring me to Wayne Metro because that's the help that they had inside of the meeting. And she told me that their lawyers are supposed to know that they don't participate with those type of parties. I really don't know exactly the details to it, but that's what I was told. Because I think I got in contact with someone from Wayne Metro like a few days after the meeting, and we were trying to do the process to go forward and make the payment. But yeah.
If you want,
I'm sorry, Miss Lacy, I wasn't trying to belabor the point, but over the last 3 years, I've heard about landlords not wanting to participate. And it was at one point that they didn't want to do their lease and they didn't want to fill out the forms and all that. But that's an aside more than anything else, Ms. Hall.
So, Your Honor, if you want to pass it for the moment, I have quite a few cases this morning with you. I can double check with my client.
I understand. Miss.
That's how much I just explained.
Ms. Hall, the court can't make Trilogy residents or any landlord participate in rental assistance programs. I don't know why somebody wouldn't if they're owed money and they have a mechanism to be paid. But Ms. Lacy's office will submit a judgment with the dollar amounts that we placed on the record earlier. You'll get a copy here shortly. Anything else, Ms. Hall?
No, my apartment doesn't accept payment plans as well. This all started because I literally was just 1 month behind. And then I was able to make the payment afterwards on time regularly, but my apartment does not accept payment plans. So they told me I couldn't pay my rent, my current rent, for the 4 months after that because I still owe 1 month, but it's like I just couldn't do it. My job doesn't allow overtime and I am in school as well. So I have money. I do have some money put up because every rent thus far that I haven't been able to pay, I have kept inside of my savings account, but I'm still 1 month short. So I'm hoping that Trilogy can maybe try to work with someone else. I don't know if it's just Wayne Metro that they refuse to work with or maybe someone else because I have like more than half of the payment that is due.
Ms. Hall, usually what happens is that the attorneys and the court don't get involved in the payment plan. That's something that you have to work out directly with the complex. And I know that complexes historically have not taken payments, don't like to take payments when there is a dispute pending, that dispute being past due rent. But once judgment enters, that changes their posture a little bit. And they are more willing to deal with people in terms of a reasonable payment plan that will have the past due amounts paid off, if that makes sense.
Yes, ma'am.
So based on the conversations we've had this morning, I'm sure Ms. Lacy will follow up with her client, number one. Number two, you should follow up with Wayne Metro regarding being able to access rental assistance. And good luck to you, Ms. Hall.
Thank you so much.
You have a wonderful day, ma'am. Thank you.
You too.
Thank you, Your Honor.
I have no problem. It's all this one stuff, which I'm trying to.
Well.
Yeah. No, the landlord tenant is paperless now. It's paperless. And Sandy sending me, Sandy,
Yes, Judge.
okay. So I saw your note and I want to pause for 1 second while we're in between things to get where I'm supposed to be. Is Malachi down there with you, Sandy?
He is not, Judge. He did not come in today.
Okay, so this is where I am, and I want to fix this so we can get back into the 9:15s. And my apologies to the people who are waiting, but we're trying to navigate this. So I am in the bench queue,
Okay.
and I'm trying to do what you asked, and
If you just click on one that says 9 a.m. and then complete the hearing, it should go out of there.
I can't do that. Is what the problem is.
Did you save your last notes?
I did. And so what I'm in right now is 429, which is West Village versus Patton, which is not what I want to be in, correct? Okay.
No, if you want to, I can move all the 9 a.m.s out. I can do that for you if that's okay.
Well, it would be okay, except I need to, okay.
You can go back in after into the hearing complete and put notes on them if you want to.
I know, but the problem is being able to navigate it, period. If that doesn't make sense to you, I'm guessing.
I'm sorry, no.
Okay, then.
Do you need me to come
We'll
up there?
stop. No, well, ideally, yes. But I
can
want to
do that.
stop because I know these people are waiting and I'm trying to figure it out, but it's not working right now. Well, Sandy,
We
would you
can do
come
it.
up? I'm sorry,
Yep,
yes.
I'll be right there.
This is 2300418 LT. This is Southport versus Sedgwick.
Good morning, Your Honor. Ryan Wojcik, P84535 on behalf of the plaintiff.
Jeremy Sedgwick. This case was scheduled for second hearing at 9:15. It's now 10:06 by this court's clock. Defendant having failed to appear. How would you like to proceed, sir?
Your Honor, we are requesting a default judgment of possession only. This is a termination matter, so there is no redemptive amount. We're asking just for under 4B, a writ date of October 2nd, 2023. We will submit an order to that effect.
Thank you. Defendant having failed to appear, default judgment shall enter with the writ date of October 2nd. Anything else in this matter, sir?
No, Your Honor. Thank you.
Thank you. This is 2300429 LT West Village versus Aaron Patton.
Good morning. How are you?
Turn your video on for me, please, sir. Ms. Lacy, this is the second hearing in this matter. What is the rent to retain possession?
Thank you, Your Honor. Sorry about that. Just shuffling to find his file. I just inserted. Your Honor, to date, the rent to retain possession is $2,320.71. Court cost of $167.65. Total balance owed $2,488.36.
Thank you. Mr. Patton, were you able to hear Ms. Lacy just now?
Yes, ma'am.
Is the amount of rent to retain possession accurate?
Yes.
Sir, in as much as you admit and acknowledge the amount of rent claim due and owing by the plaintiff is accurate, there is no triable issue of fact and plaintiff is entitled to entry of judgment in that amount being $2,320.71 in rent, $167.65 in court costs for a total judgment of $2,488.36. Plaintiff's office will submit a judgment to the court that indicates those amounts with a pay or move date of October 2nd, 2023. Mr. Patton, did you have any questions this morning?
No, ma'am.
Did you need to access rental assistance, Mr. Patton?
Nope, it'll be paid before the 22nd.
Thank you, sir. That concludes this matter. You're free to go. You have a wonderful morning.
You too. Thank you.
Thank you. Oh, for the love of mankind. Is that? Thank you. So what I'll do. Okay. So what I'll do is just do this
I'll holler at you.
and then go back in and fix them. Okay. I know. I was overwhelmed when I sat down. Thank you. This is 2300430 LT. This is West Village versus Pearson and Pearson.
Yeah, Taylor and Preston Pearson here.
Here.
Gabriel Lacey for West Village Estates.
Thank you. Today is the day and time set for the second hearing on this matter. Ms. Lacy, what is the rent to retain possession?
Today, the rent to retain possession is $2,504.25. Cost of $167.65. Total balance owed $2,671.90.
Were you able to hear the amount of rent claim doing owing by the plaintiff?
Yes.
Is that amount accurate?
Yes.
Do you have any defense to this non-payment of rent action?
I have a tracking number for SER. Currently, it's being processed to take care of the balance.
Ms. Lacy, is that tracking number beneficial to you?
No.
Okay. Ms.
Well,
Pearson, I
my
heard you.
Your Honor, I'm sorry.
I'm sorry, go
The
ahead.
property manager is here. But I don't, I think that we're just gonna proceed with judgment, but I could.
Yeah. Yes, I did speak with somebody from office, and she is aware that we have the tracking number and SER is being processed. But I do believe that they were still going to move forward with the default until SER goes through.
Thank you.
That is
Ms.
correct.
Pearson, Ms. Pearson, as much as you admit and acknowledge that the amount of rent claim due and owing is the amount that Ms. Lacy placed on the record, there's not a tribal issue of fact, and the plaintiff is entitled to entry of judgment in that amount. The pay or move date, the writ date will be October 2nd, 2023, and Ms. Lacey's office will present paperwork that shows that amount. Ms. Samples has acknowledged receipt of that tracking ID number. What I would suggest is that you continue to monitor the situation and follow up and make sure that the $2,671.90 is paid, or there is some other arrangement. But the court does not get involved in the payment plans that parties reach in these matters, if that makes sense to you.
Yes.
Okay. Anything else this morning, Ms. Pearson?
No, just it'll be taken care of by the end of this week. So
I appreciate that, ma'am. You have a wonderful day, okay?
thank you. You too.
Thank you. Ms. Hall, how may I help you?
Was I free to leave, or should I stay until the end of the court meeting?
Oh, no, ma'am, you're free to leave. I'm sorry. I thought I said that at the end.
I'm sorry. Okay, have a great day.
No, you're fine. Have a good day, ma'am. This is a recall of 2300276T Woodside versus Austin. Ms. Snyder, were you able to make any progress in the breakout?
We have a conditional dismissal and in terms that we're ready to enter into.
And the terms of that will be?
The rent to retain is $801 with the cost of $164 for a total of $965. Pay or vacate by October 16th. The defendant will also pay October rent as it comes due. And I explained I checked box 4B and explained that to Miss Austin as well as box 7. And we talked about MCR 4.201. Miss Austin, do I have permission to sign your name to this conditional dismissal for entry?
Yes.
Miss Austin, was everything else that Miss Snyder said accurate regarding the amount of rent claim due and the court costs?
Yes.
And ma'am, you understand that this amount must be paid or you vacate the property by October 16th.
Yes, both will be done.
Thank you. And that this conditional dismissal was in an effort to protect the Section 8 status that you indicated was so important.
Yes, ma'am.
Did you have any questions at all this morning, Miss Austin?
No, I just want to know that the first hearing thing won't affect me either, because I don't see how it was sent out on July 31st if I owe August rent. That doesn't make sense. But I just want to make sure that's not going to affect me either.
It won't affect you as far as the court is concerned, Ms. Austin. When I put notes in regarding today's hearing, I'll make a note about that because it's curious. But it doesn't affect the entry of the conditional dismissal this morning.
Okay, thank you. That's all I wanted.
I appreciate you for working with Ms. Snyder. Ms. Austin, you have a wonderful day, okay?
You as well.
Thank you.
Thank you, Your
You're
Honor.
free to go, ma'am.
Thank you, Your Honor. We'll get that sent over.
Thank you. This is 2300459LT. This is Southport Apartments versus Pamela Ward.
Good morning again, Your Honor. Ryan Wojcik, P84535, on behalf of the plaintiff.
Pamela Ward. This case was scheduled at 9:15. It's now 10:16 by the court's clock. Defendant has failed to appear, sir. How would you like to proceed?
Your Honor, I will just note for the record, I did see someone logged in as Devonte Pamela Ward this morning. I did see that more than a half an hour ago. I would ask to proceed by default, but I just wanted to make the court aware.
Judge,
Yes.
I checked Devonte in. He stated that she is pregnant and is having some complications and is currently at the hospital.
Then what we'll do is adjourn this matter over a week, sir, respectfully.
Do we have a
Sandy
date
did
for
tell
that?
me earlier that someone had checked in, but if she wasn't sure about the case, we'll put it over till next Wednesday. Let's make a note on the file of what happened. And when you appear or Mr. Herman's office appears next week, we'll be sure to take that case as early as possible, given the fact that it will be in fact the third hearing in the matter.
Thank you, Your Honor.
Thank you. This is 2300460 LT Southport Apartments versus Brandy Burkholder and Justin Parrish.
Good morning again, Your Honor. Ryan Wojcik, P84535, on behalf of the plaintiff.
Burkholder or Parrish. Today is the day and time set for the second hearing in this matter. Case was scheduled at 9:15. It's now 10:18 by the court's clock. Defendants have not responded to the court's call. Sir, how would you like to proceed?
Your Honor, we are asking to proceed by default. This would be a possession judgment only. Rent to retain in this matter of $3,799, cost of $198, for a total redemptive amount of $3,997, requesting a writ date of October 2nd, 2023. We will submit an order to the court to that effect.
Thank you. The court will enter that default judgment with a total due of $3,997 and a writ date of October 2nd. This is 2300461 LT. This is Southport versus Jada Griggs.
Good morning again, Your Honor. Ryan Wojcik, P84535, on behalf of the plaintiff.
Good morning, Your Honor. I'm Jada Griggs.
Thank you. Today is the day and time set for the second hearing. What is the rent to retain possession in this matter?
Your Honor, based on the books and records of my client, we're showing rent to retain of $3,320.50, cost of $164, for a total redemptive amount of $3,484.50.
Thank you. Ms. Griggs, were you able to hear the attorney just now?
Yes, I heard him.
Is that amount of rent due and accurate, claim due accurate, $3,320.50?
Yes, it's accurate, Your Honor.
Ma'am, inasmuch as you admit that the amount of rent claim due is accurate, there is not a tribal issue of fact and plaintiff is entitled to entry of judgment in that amount. The judgment will indicate that you must pay this amount or vacate by October 2nd. Ma'am, do you have any questions regarding this matter?
Yes, I was wondering if well, I do have a SER in hand. I mean, yeah, I have a SER going on, but I was wondering because I just started my job. I was wondering if I could get until like the 13th. I would have like half of the payment on the 29th, and then I get paid again on the 13th of October.
Your Honor, if I may, I don't have authority to go beyond the standard 10 days. I would definitely recommend that Ms. Griggs reach out to the landlord to see if they can work out a payment plan that gives her more time than the 2nd of October. But at this time, I am requesting the standard 10-day judgment.
Ms. Griggs, the court will leave it as is, as October 2nd being a pay or vacate date. But again, please be in contact and communication with your landlord regarding a payment plan. This court does not get involved in the payment plans by and between the parties. And Ms. Griggs, although you have an SER number, would it be beneficial to you to maybe speak to a representative from Wayne Metro regarding other financial resources?
Yes, that'd be good.
Thank you. Ma'am, Southport's attorney will submit a judgment to the court with the dollar amounts and the writ date that we just discussed. That will conclude the matter as far as the court is concerned, but you'll see an invitation to go into a breakout room with Ms. Remke from Wayne Metro. She'll discuss with you other financial resources. And I will again encourage you to be in contact and communication with your landlord regarding a payment plan, okay?
Okay, and also another thing, do they accept the payments from other places? Southport to the plaintiff?
I believe the plaintiff will accept any checks directed to them on your behalf. I don't know what SER or Wayne Metro is requiring right now. I know several of my clients have issues with addenda to the lease, but I would just suggest you reach out to the landlord and see if they're willing to cooperate. Personally, I believe we should always cooperate, but that is, not my client's position at every property.
Okay, sounds good.
Thank you.
Thank you. Ms. Griggs, you'll see an invitation to go into room number 14. Please go there. There will be a representative there to talk to you, okay?
Okay, thank you.
Thank you. Mr. George, what did you have, sir?
Tenant Rima Hawkins. I just put in the chat that I was stepping away back now.
I know that you're back, but what case are you here for?
Oh, it's US versus Karima Hawkins set for 10 a.m.
I don't have a 10 a.m. case, sir. Are you in the right courtroom?
So I see opposing counsel here as well.
Oh, that's
Judge,
not a
this
good
one was
sign.
not set, but it is on your bench. Virtual bench.
Have you had an opportunity to speak this morning with opposing counsel, Mr. George?
Not today, but we did exchange emails yesterday, and unfortunately, I don't think we're going to be able to resolve this.
Okay, let me call the 9:30 cases. Sandy, I'm still looking. Hold on. I
Your
don't see
Honor.
it just yet.
Your Honor, I just want to confirm my last matter was a dismissal that was received by the court before I logged off. It was 485 McKnight, correct?
I don't see it yet, sir. But I'll make a note on my sheet that it's a dismissal. Other than that, you're free to go. Thank you for your patience.
Thank you, Your Honor. Have a great rest of your day. Thank
you. Sandy, I see your note now. Sorry.
Okay, and Laura's bringing up the docket for you.
Mr. McGeorge, sit tight. Let me do these 9:30s and I'll be right back to you. This is 2300205 LT Trilogy versus Wellington.
Gabriel Lacey for Trilogy Apartments, Your Honor.
Tierra Wellington. This case was scheduled at 9:30. It's now 10:24 by this court's clock. Defendant failing to respond to the answer to the call. Ms. Lacey, the rent to retain possession is.
Your Honor, $5,671.81, cost of $168.28. Total balance owed $5,840.09. We are going to request a default judgment for possession only.
Absolutely. Default judgment with a total due of $5,840.09. Plaintiff's office to submit that judgment for entry. This is 2300206 LT. This is Trilogy versus Ebony Wilson.
Gabriel Lacey for Trilogy, Your Honor.
Ebony Wilson. Today is the day and time set for the second hearing in this matter. Case was scheduled at 9:30. It's now 10:25 by the court's clock. Defendant has failed to appear this morning, failed to respond to the call. Ms. Lacey, what is the rent to retain possession?
Your Honor, give me one moment.
While you're looking, Ms. Lacey, Ms. Griggs, unless you had any questions, ma'am, you're free to go.
I was looking for the breakout room to talk to somebody.
Oh,
I didn't get the invite.
Here we are. I'll send it to you again, Ms. Griggs. Ms. Lacey.
Ms. Wilson is dismissed, Your Honor, and you'll be getting a dismissal.
The court will note that there is a dismissal coming as relates to Ebony Wilson. This is 2300218 LT West Village versus India Bryant.
Gabriel Lacey on behalf of West Village, Your Honor.
I'm here.
State your name, please, ma'am.
India Bryant.
Thank you. Today is the day and time set for the second hearing in this matter. What is the rent to retain possession, Ms. Lacey?
To date, the rent to retain possession is $2,251.79. Court cost of $167.65. Total balance owed $2,419.44.
Ms. Bryant, were you able to hear Ms. Lacey just now?
Yes.
Ma'am, is the amount of rent claim due accurate?
Yes.
Ms. Bryant, do you have any defense to this non-payment of rent action?
Say that again?
Do you have any defense to this non-payment of rent action?
No.
Ms. Bryant, inasmuch as you admit that the amount of rent claim due and owing is accurate, there is not a tribal issue of fact, and plaintiff's office is entitled to entry of judgment with rent to retain possession of $2,251.79, $167.65 in court costs for a total of $2,419.44. Ms. Lacy's office will present to the court a judgment that shows those dollar amounts with a date of October 2nd to pay or vacate. Ms. Bryant, do you need to access rental assistance or information regarding rental assistance, or do you have a plan to pay this amount? Ms. Bryant?
No, I'll get the help. Could I call Wayne Metro the last time I went to call, but I just see that you have a Wayne Metro. Yes, can you hear me?
I can hear you, ma'am. You're just breaking up a little bit. Ms. Bryant, we can get you moved into a breakout room and you can discuss. Oh, there we are. If you want to move into the breakout room and discuss with Ms. Darla some
Okay, that's fine.
rental assistance. Okay. Ms. Bryant, after you have the opportunity to speak to her, you are free to go, okay?
Okay, thank you. Have a good day.
You too, ma'am. Thank you. This is 2300409 LT. This is West Village versus April Davis and Rebecca Morgan.
Gabriel Lacy on behalf of West Village, Your Honor.
Ms. Davis, you need to unmute yourself, turn your video on, and state your name for the record, please.
April Davis.
Thank you. Do you know where Rebecca Morgan is?
I have not known where she is since August. I don't know.
Thank you. Today is the day and time set for the second hearing in this matter. Ms. Lacy, what is the rent to retain possession?
Rent to retain possession is $4,283.05. Cost of $167.65. Total balance owed $4,450.70.
Thank you. Ms. Davis, were you able to hear Ms. Lacy just now?
Yes, ma'am. Yes.
Is the amount of rent claim due accurate?
Yes.
Ms. Davis, do you have any defense to this non-payment of rent action?
Actually, no, Rebecca has been away from the place since August, right after she signed the lease, and I just been struggling to pay it on my own. So I kind of fell off, and for my last month, actually, my lease was up July 31st. So it's for a non-payment for July, and then August, and of course, September. So.
Ms. Davis, inasmuch as you admit that the amount of rent claim due and owing is accurate, there is not a tribal issue of fact, and plaintiff's office is entitled to entry of judgment as requested. Ms. Lacy's office will present a judgment to the court that shows that there is rent to retain possession of $4,283.05. Plaintiff is entitled to entry of court costs of $167.65 for a total judgment of $4,450.70. The judgment will indicate that you must pay this amount or vacate the property by October 2nd. Ms. Davis, do you have a plan for rental payment, or do you need to speak to someone from Wayne Metro regarding rental assistance?
I would love to speak with someone in reference to rental assistance, but I do have a couple of questions. I did try to reach out in reference to possibly trying, well, actually I can speak with them to try to do some maybe payment arrangements, and also to see how I would go about maybe trying to have Rebecca be responsible for, you know, part of this payment. How do I go about doing that?
Ms. Davis, typically what happens is when there are multiple people listed as tenants, the landlord is able to proceed against one of you, all of you, or whatever configuration. So the landlord, just wants the rent paid. You
Right.
going against Rebecca would typically be something outside of this summary proceeding, this landlord tenant action, if that makes
Okay.
sense to you.
Yes, ma'am.
So what I'll do now, Ms. Davis, Ms. Lacy's office will send that judgment over. I'll sign it. A copy will be mailed to you at the address we have on record. But you'll see an invitation to go into a breakout room and meet with the representative from Wayne Metro to discuss maybe some rental assistance that's available.
Okay. Okay. And
Okay.
I did have one more question as well. So it says I have to vacate by October 2nd, because unfortunately I don't have the payment. And then also, I did have another question. I'm sorry. Does the amount reflected, does that reflect the security deposit as well? Or is that already included into the 4450?
It is not, ma'am. The security deposit doesn't come into play until you vacate the property.
Okay. Okay. So then will it be subtracted from this amount, or how does that work? I don't.
Typically, that's how that works.
Okay.
But ma'am, there are online resources that explains how security deposits work and what
Okay.
landlords have to do and what your obligations are on move out, so that security deposit information is relayed to you. Okay.
Okay. Okay. All right. Great. Thank you so
Anything
much.
else, Ms. Davis?
No, thank you. No, thank you.
If you think of anything else, again, there are online resources available to you. But what you'll see right now is an invitation to go into room number 14 to meet with Wayne Metro. Go there, speak with them, and after you're done talking to them, you're free to go. Oh, she's gone. That was fast. This is 2300420 LT. This is Bill versus Ellis Door.
Kimberly Lacy for Bill Properties, Your Honor.
Miss Lacy, this case was scheduled at 9:30, is now 10:34 by the court's clock. The defendant, Monique Ellis Door, failed to appear for the first hearing, has failed to appear for the second hearing. How would you like to proceed?
Yeah, at this time, we would request a default judgment for possession only. The rent to retain possession is $2,500, cost of $166.63. Total balance owed $2,666.63.
Thank you. Defendant having failed to appear, default judgment in favor of plaintiff and against defendant with rent to retain possession of $2,500, court cost of $166.63 for a total judgment of $2,666.63. This is 2300422 LT West Village Estates versus Dustin Henson.
Gabriel Lacy on behalf of West Village Estates.
Dustin Henson. This case was scheduled at 9:30. It's now 10:35 by the court's clock. Defendant has failed to appear for a second time in this matter. Plaintiff is entitled to entry of default judgment. Ms. Lacy, what is the rent to retain possession?
Rent to retain possession is $2,970.40, cost of $167.65. Total balance owed $3,138.05.
Default judgment shall enter in that amount. Thank you, ma'am.
Thank you.
This is 2300443 LT West Village Estates versus Jerusha Williams. Your appearances, please.
Gabriel Lacy for West Village Estates.
State your name for me, please, ma'am.
Yes, ma'am. Jerusha Williams.
Thank you. Today is the day and time set for the second hearing. Ms. Lacy, what is the rent to retain possession in this matter?
Rent to retain possession is $2,426.86, cost of $167.65. Total balance owed $2,594.51.
Ms. Williams, were you able to hear Ms. Lacy just now?
Yes, ma'am. I'm sorry. I think she said $2,594.51.
Yes, ma'am.
Yes, ma'am.
Is that an accurate amount of rent claim due and owing?
Yes, ma'am.
Ms. Williams, do you have any defense to this non-payment of rent action?
No.
Ma'am, as much as you admit and acknowledge the amount of rent claim due is accurate, there's not a tribal issue of fact, and plaintiff is entitled to entry of judgment in that amount with rent to retain possession of $2,426.86. There's $167.65 in court costs for a total judgment of $2,594.51. $94.51. Ms. Lacy's office will submit a judgment to the court with those dollar amounts on it. It will be signed and mailed to you at the address we have on record. Do you have any questions this morning, Ms. Williams?
No, ma'am. I'll have it taken care of by Friday.
Ms. Williams, thank you for your patience this morning. You're free to go. You have a wonderful day, okay?
You all too. Be safe. Bye-bye.
Thank you, ma'am. This is 2300425 LT West Village Estates versus David Jones.
Gabriel Lacy on behalf of West Village Estates.
David Jones, today is the day and time set for the second hearing in this matter. Ms. Lacy, I'm just checking. There is no one by that name in the court's breakout sessions. This case was scheduled at 9:30. It's now 10:38 by this court's clock. This is defendant's second failure to appear. Default judgment shall enter in favor of plaintiff and against defendant. The rent to retain is
$3,869.27, cost of $167.65, total balance owed $4,036.92. Requesting default judgment.
absolutely. Default judgment shall enter in that amount with a total judgment of $4,036.92 on the defendant's default this morning. This is 2300427 LT West Village Estates versus Carrie Mitchell.
Good morning.
Gabriel
State your name,
Lacy
ma'am.
for- Gabriel Lacy for West Village Estates.
I'm sorry, Ms. Mitchell, I was asking you to state your name, please.
Oh, Carrie Mitchell, sorry.
No worries. Today is the day and time set for the second hearing in this matter. Ms. Lacy, what is the rent to retain possession?
$699.08, cost of $167.65, total owed $866.73.
Ms. Mitchell, were you able to hear Ms. Lacy just now?
Yes,
Ma'am, is the amount of rent claim due and owing accurate?
yes.
Do you have any defense to this non-payment of rent case?
Right now I'm on strike with Ford. And so right now I'm trying to do the money in between the mortgage and the lot rent, but I'll have the rest of the lot rent paid by the end of the month.
Ms. Lacy, do you have any
I
authority
don't
from your
have the
client to?
authority to, well, if she's gonna be paid by the end of the month, then that would be before the rent date. So we'd still be
Ms.
asking for a
Mitchell?
judgment.
Okay, I'm sorry. Ms. Mitchell, you're saying that you are able to pay before October 2nd, which will be the rent date?
Yes,
Ma'am, what the court will do is enter a judgment with the amounts claimed due and owing by the plaintiff, $699.08 for rent, $167.65 for court costs, a total judgment of $866.73. If something changes, Ms. Mitchell, and you need, and you're not going to be able to have that amount paid by October 2nd, I would encourage you to reach out to your landlord.
mm-hmm.
Okay?
Okay. Is there a way I can
Anything-
talk to Darla also?
Absolutely. That was going to be my next question to you. I know that strike pay is what it is.
It's terrible.
Listen, you all are doing a great job up there on Michigan Avenue and over there on John Hicks. I've been by there. I understand completely.
Thank you.
So what we'll do, solidarity, ma'am.
Thank you.
What I'll do is I'll get you moved into a breakout room with Ms. Remke.
Okay.
Give me one moment. You should see an invitation pop up to go in there and talk to her, okay? We're gonna have to come up with a plan for that. 2300487 LT Trilogy versus Jason Sims. This case was scheduled at 10:30. It's now, this case was scheduled at 9:30. It's now 10:42 by the court's clock. This is the defendant's second failure to appear. Ms. Lacy, rent to retain possession.
$4,773.69, cost of $168.28. Total balance owed $4,941.97.
Default judgment shall enter in that amount. Anything else in this matter, Ms. Lacy?
Nothing further, Your Honor. Thank you.
Thank you. Mitchell. Miss Lacy, is that it?
Did you call Starsky for West Village Estates 435?
435.
I'm checking on it now, Judge.
I'm sorry. Sandy, I couldn't hear you.
I'm checking on that one now.
Thank you.
We also have Miss Davis here for West Village.
She's not really here.
Oh,
That's the court Zoom room. She's gone. It just hasn't been relabeled yet.
okay.
I just want to make sure before we move on to the 10 o'clock case, because I still see Miss Young. Sandy, you were in that. You locked me out of it. Oh, good. Now you're out. And then Ward at 9:15.
On the 0435, is that Kirk Starsky?
Yes.
Okay, we did not put that on the docket. Do you want me to go ahead and put it on for next week, Judge? Or we just never sent any notice out?
I don't have any idea what the case is, so I'm guessing you probably should put it over for next week.
Okay,
What's the
it's just
missing
an-
case file number? I'm sorry, Ms.
23.
Lacy.
2300435 LT.
Sandy will notice it up for next week. The last thing I have is the 10 o'clock. And I think that concludes your docket this morning, Ms. Lacy.
I think you are correct, Your Honor. Always a
I
pleasure.
promise you, next week will be smoother.
That's all right. New technology is hard to get a hang of. Have a great one.
Take care. Ms. Mitchell, was there something else? Ms. Mitchell, you're muted, ma'am.
I'm sorry. No, I didn't know if I had to come back out because you were talking and then it like booted me into the room. So I didn't know if you had anything else to say.
Oh, no, I didn't.
Okay.
Had you already gone in and spoken to Wayne Metro?
Yep.
If you don't need anything else, ma'am, you're free to go.
Okay. Have a good day.
You too. Thank you, ma'am.
Thank you.
This is 233434 LT. This is U.S. Government versus Karima Hawkins.
This is Ellis Friedman, the attorney for the plaintiff.
Good morning, Your Honor. George Lakeshore Legal Aid on behalf of Karima Hawkins, who is present in the Zoom courtroom.
Thank you. Today is the day and time set for hearing in this matter. The parties have had the opportunity to speak. How are we proceeding this morning, Mr. Friedman?
Well, Your Honor, I would prefer to take a judgment of possession. There's a final order from the district court in the Middle District of Tennessee awarding the property in question to the U.S. government, and we would request a judgment of possession at this time.
I'm sorry, I'm going to interrupt you for 1 second. I'm going to step off for just 1 second, but I'll be right back. I know that I saw this case before. Give me one moment.
Probably the exam.
Mr. George, your response to that request?
Yes, Your Honor, we're seeking a stay of proceedings in this matter. So the Tennessee court case was a criminal case that was prosecuted against Ms. Hawkins' ex-husband. She had no knowledge of his criminal activities. To her knowledge, this house was legitimately purchased and it was awarded to her in a divorce. There is currently pending a separate civil case that Ms. Hawkins has filed in the Middle District of Tennessee seeking recovery of the property that is still pending. And there's also a case in the Third Circuit Court of Michigan to quiet title, and I don't believe that that has been resolved as to Ms. Hawkins. So we're simply seeking a stay of proceedings pending the outcome of those cases.
The Tennessee case is a case where Ms. Hawkins in pro per has filed a complaint that purports to request the court to set aside its previous orders of forfeiture, claiming innocent spouse and so on and so forth. However, that was disposed of in the previous forfeiture case in which her interest was adjudicated, and it was determined that she was not an innocent spouse under the statute, and that her interest had been forfeited to the United States long before any award was made to her of any property. Those arguments have already been made and been decided by the United States District Court for the Middle District of Tennessee. As far as the quiet title action is concerned, the federal court has determined that title was vested in the government prior to the divorce even being commenced.
So is there currently a circuit court action pending with these parties, Mr. George?
Yes, Your Honor, my understanding is that there is. I looked at the register of actions the other day, and it appears to still be pending as to Ms. Hawkins. It may have been disposed of as to other parties that were involved, but I believe Ms. Hawkins is still fighting that case.
Well, there's no stay, Your Honor, from the circuit court in Wayne County. There's no stay in federal court. There are no stays that are in place. I understand his position, but he's simply asking this court to, in effect, impose a stay on appeal for cases that aren't on appeal. There's a final judgment of forfeiture that's now over a year old.
My response to that, Your Honor, would be that Ms. Hawkins has the right to attack that judgment. We're just asking this court to hold off until she's had her opportunity to do so.
Well, she's had opportunities for the last couple of years, and she's failed at every turn, and in fact been found to have furnished the court in Tennessee with a fraudulent deed. So she's grasping for straws. I understand Mr. George's position. I sympathize with his position, but she's grasping for straws. She's filing cases that will be summarily dismissed, and asking this court to stay proceedings while she files frivolous cases. She's going to keep filing until the cows come in.
And that's one of the reasons why the court wanted to look at the notes. I don't see any of what Mr. George, did you file an answer in this case?
I did not, Your Honor.
Okay. Mr. George, if it's your position that this court should stay the matter as these same parties are involved in a circuit court matter that is pending, this court would, of course, stay the proceedings, but there's no notice that is what the argument is in the case, or that this circuit court matter would effectively stay these proceedings.
I can provide the court with the case number and a copy of the register of actions. Unfortunately, I'm not able to pull up any of the filings in that case.
that case is a quiet title action that involves the banks and so on. It's eliminating interests, collateral interests in the property. It's not going to result. That case is not going to result in, couldn't result in the defendant getting anything as a result. It's not legally feasible. She never had a vested interest in the property. It never belonged to her. It was only named, the only named person that the property was deeded to was Bradley. It wasn't her. She never was on the deed ever. She furnished a fraudulent deed to the court, which they didn't sanction her, but they cautioned her that the deed that she had furnished was not real.
My understanding is that
Mr. Friedman, Mr. Friedman, of concern is that this case did not even appear on the docket when I was preparing 2 days ago. It was just added this morning. They brought the docket sheet up to me. I'm now looking in on base, and there's a copy of an order or an opinion, memorandum and order from the U.S. District Court for Tennessee, the Nashville Division, United States versus Bradley. And the fact that it appears in the court's file suggests that it is really related to this case in some way, shape, or form.
It is, because it disposes of Ms. Hawkins' argument.
And I'm referencing it because I haven't had the opportunity to review it. I was not made aware of the circuit court case until the case was called this morning. And I know that you both have been waiting patiently for these other matters to be heard. Mr. George, are you in receipt of this memo and order?
I believe so, Your Honor. Mr. Friedman did provide me with a copy of that. I think it's the same thing that you're looking at.
It is.
And Mr. George, have you had the opportunity to review this order?
Yes, I have, Your Honor.
So, Mr. George, the court has just gone to the last page of this order, and it indicates that Hawkins' motion to extend time was granted, but her claim is denied. The government's motion for entry of a final order of forfeiture is granted. Why should this court do anything other than convey possession to the government as requested by Mr. Friedman?
Your Honor, this is Ms. Hawkins' home. This is where she raises her children. She doesn't have anywhere else to go. She's been trying to save this home for years. Again, she's attacking that judgment collaterally through a civil action filed in the Tennessee court. We just want to see the outcome of that case before she loses her home.
Well, she actually sued the 4 U.S. attorneys that represented the government. It's a convoluted lawsuit which can't address these issues. It's a lawsuit. It's not.
Well, Mr. Friedman, what I started to say originally was that this matter was not on the docket. This court has not had a chance to review the order in its entirety and would like an opportunity to do that. And Mr. George, if there's something that you want to present to support your position that the U.S. government is not entitled to possession of the premises, how long would it take you to get something submitted?
Just a couple of days, Your Honor.
I would note, Your Honor, I'd agreed to adjourn this case for 1 week with Mr. George about 4 weeks ago. Here we are. I'm not opposed to a 1-week adjournment, Your Honor, for you to have all the time you need to look at anything that is submitted.
I'm just asking for 1 week, sir, because I'm looking at the ROA right now and it appears that the case was scheduled on the 16th and then it was adjourned because I remember reading something about this previously and didn't know what had happened, and it wasn't placed on the docket until just this morning. So, Mr. George, if you're able to get whatever it is that you want the court to consider to my file by the end of this week, and are you both available next Wednesday morning? Wednesday, the 27th?
Yes.
Yes, Your Honor, and it looks like I will be appearing before you at 9:45 a.m. So I'll already be here.
I just want to look because I don't want you stuck behind
In person, 14B.
heavy traffic on that date.
We have Romer. Case evaluation. That's what I'm here.
I can do the morning of the 27th.
Thank you, sir. I'm just trying to check the schedule to see what's already scheduled. Oh, that can't be right. It says 200 cases. I know that's not right. The last thing we have scheduled is 9:45. So we say 11 o'clock. And Mr. Friedman, if there's anything by Zoom, if there's anything else that you want the court to consider, have it filed by 3 o'clock this Friday. Same thing to you, Mr. George, by 3 o'clock on 9/22. And I'll review the United States order, not United States District Court order, along with whatever it is that you present on next Wednesday at 11 a.m. by Zoom. We'll take
Thank
up we'll take up your arguments further.
Your Honor, may I just ask Ms. Hawkins if that date and time works for her as well? I want to make sure that she's able to be here. Ms. Hawkins, you're muted. Could you speak up, please?
Yes, sir.
That works for you?
Yes, sir.
Okay, thank you.
11 o'clock?
Yes.
Okay.
Next Wednesday at 11 a.m. Thank you, gentlemen, for your patience. Ms. Hawkins, thank you for your patience.
Thank you.
Thank you, Judge. Have a good
Thank
weekend.
you, Your Honor. And thank
You
you, Mr.
too.
Friedman. Ms. Hawkins, I'll follow up with you by phone later this week, okay?
Thank you. Have a great day. Thank you.
You too. Bye, everyone.
Darla, thank you for joining us this morning. I might walk over and chit chat with you later. I have landlord tenant again next week. It might be nice to know what exactly we can do or your office is able to do during the course of these hearings, okay?
Absolutely. Thank you for having me.
Of course, thank you.
All right, I'll be here till 4.
Sandy. Oh, wonderful. Okay.
Bye-bye.
Sandy,
Yes, Judge.
I saw your message and April Davis was 2300409.
Yeah. Was it on the docket?
It's on the docket. We talked. She
Oh,
confirmed the
okay.
balance. I'll make some notes later.
Okay, because the manager said, Miss Davis is here, and I'm like, oh my gosh, what didn't we do? And so I thought we
What?
didn't do something.
She was in our Zoom, and because she was in our Zoom, when she left, her name stayed up.
Okay, okay. I just wanted to make sure we didn't miss her, so, okay.
We
And I
didn't
am,
miss her.
it isn't totally my fault in regards to the US government one. I don't know how that happened, but when I seen them both on